There's mixed news from the North Carolina Appeals Court for a property owner involved in a long-term fight with the town of Apex involving property rights. Joining us with reaction to the latest development is John Guze. He is senior fellow in legal studies at the John Locke Foundation. And this is a case, Town of Apex v. Rubin. Before we get into what the Court of Appeals said, remind us, John, what are some of the basics of this fight between a property owner and the town in Wake County known as Apex?
Well, let's go back to when this all started. Many years ago, Beverly Rubin owned this property in, at that time, a fairly rural part, undeveloped part of Wake County. A developer came in and bought some adjacent parcels, wanting to develop them as a subdivision. He wanted to get it. He asked her if she would sell him an easement across her property so that he could provide sewage access for the new subdivision, and she said no, which is her right. Instead of accepting that, he went to the town of Apex, and they made an agreement under which Apex would take the easement by eminent domain, and he would pay all their costs to do so. On that basis, he was able to sell the property at a profit of over a couple million as a developable parcel, which wouldn't have been the case if it were not for the sewage easement. So far, so good, you might think. Sewage easements, after all, are pretty typically the kinds of public uses for which the eminent domain statute exists in this state. But Beverly Rubin wouldn't accept that. And when the town of Apex filed their lawsuit asking for eminent domain, she challenged it, and it was proceeding in the courts. But the town didn't wait to see how the courts would handle it. They went ahead and used a different statute, our quick take statute, that allowed them to go ahead and take control of the property on a temporary basis while waiting for the courts to decide. And they went ahead and they installed the sewage line. Lo and behold, when the district court heard the case, they said, no, you know what? This is not a public use. This was really done to help the developer. It was for a private use, and we're not going to allow this taking. So there we were with sewer already installed, subdivision under development, and court saying it's not a public use and this taking is null and void. Now, the town of Apex didn't take that line down. They went ahead and they said, okay, if we can't take this through eminent domain, then this is what we're going to call this a taking that we still get to do it because we've already got effective title to the property, and Beverly Rubin's only remedy is going to be damages. And they offered to pay her some nominal amount of money, I think it was $6,000 or $8,000. And again, she said no. So this went all the way up to the North Carolina Supreme Court, and at every level, the town lost, and Ms. Rubin won, but the court still didn't accept. The town still didn't accept it. They filed their own lawsuit, in fact, a couple of lawsuits. And when these were heard in district court more recently, the district court sided with the town and said that her only remedy was damages and that the sewage line would have to stay.
So
that's
the case
before the Court of Appeals this time around.
Right. So the case goes to the Court of Appeals. This is a case that has interested you so much that you joined together with another lawyer and put together a friend of the court brief in the case. Why was this something of such interest to you?
Well, eminent domain is one of the topics that the John Locke Foundation has always been very interested in. We think property rights are important. We think that eminent domain should be limited to public use. And we think that, if anything, what North Carolina needs are stronger protections, not lower protections. This seemed a pretty clear case that we had to step in, because if the town can take the property, even after a court has said it's not for a public use, that's really going to eviscerate the power of our constitutional right not to have property taken except for a public use. That's why we stepped in. We wanted to vindicate the principle here, regardless of the complications of this particular case.
So this case went before a 3-judge panel of the North Carolina Court of Appeals. We now have a ruling from that court, unanimous, written by Judge Lucy Inman, and some mixed news for Beverly Rubin. But in general, from your perspective, good ruling?
I like this ruling very much because it absolutely vindicated the constitutional principles we care about. The court said, you know what, the district court got this wrong across the board. This was a taking It was a taking that was not for a public purpose. And as a result, Beverly Rubin's got full title to that property, free and clear. And the town of Rubin has got no right to maintain a sewer line across it.
Yeah. And in fact, basically, the Court of Appeals did not take the action that Beverly Rubin wanted, in effect, telling Apex, you got to get rid of the sewer line. But it did say you could file another case saying that this is a trespass and argue to have that sewer line removed if you want.
That's right. If she had asked for injunctive relief at the outset, if she had said, you've got to remove this line, when she first started litigating with the town, I think this would have been a complete win for her, and the town would have just had to do something about removing or no longer using that sewer. But because she failed to do that, the court rightly, in my opinion, decided that they couldn't make a ruling on that. If she wants to have that line removed, or at least to get them to stop using it, she's going to have to file a trespass claim against the town of Apex, because since that's her property, free and clear, and they've got no legitimate right to be there, they're trespassing. They're trespassing every single day.
Sometimes court decisions are very dry, full of legalese, kind of boring. This one actually was pretty feisty in some respects, in terms of the way it described what the town of Apex did, and also what the trial court did. Judge Inman and her colleagues weren't too happy about it.
No, it was really what we call a bench slap across the board. They were very critical of the town. They were very critical of the district court. They said that the town abused its powers, and that the district court judge really got it wrong. His reasoning was wrong at every single stage in the process. So it was on that side. It was a thorough takedown and a great win for property rights to North Carolina.
Now, whatever happens with this case, because presumably, even though it was a unanimous decision, the town could try to appeal back to the Supreme Court. So we don't know how it's going to be resolved. But you hope that this case will help spark some interest in changing the law.
I do. Quick take. It's an interesting idea. You can see why the legislature might have thought it was a good idea. Originally, this was meant to be used by the Department of Transportation when they're building roads, and the idea was to keep things moving even while court cases are pending. Now, when the Department of Transportation takes property for a road, that's almost certainly going to be a winner. That's a public use by any definition of the word. The thing that's a little odd, though, is that certain municipalities in North Carolina have also been given the power to use the quick take statute. That's where I think it's time for the General Assembly to rethink this. I'm not so sure it's a good idea for municipalities to have that power. They're not as sophisticated as the Department of Transportation, and their uses are much more likely to be questionable, as it was in this case.
Well, it's certainly an interesting case, not resolved, but the latest news, generally pretty good for Beverly Rubin, the plaintiff who is challenging the town of Apex and its violation of her property rights. We know as this case moves forward and reaches a final resolution at some point, one person who will be watching very closely is John Guze. He is a senior fellow in legal studies at the John Locke Foundation. John, thanks so much.
Thank you, Mitch.